USCIS is pretty much being consistently inconsistent and sort of took the claim extension for granted inquiries so we can put it into the record. Otherwise, it would just create a disaster down the road. So I think on the investor petition side, the overarching theme that I would describe is USCIS is pretty much being consistently inconsistent. By being consistent, I mean like this is an issue that we've seen from USCIS for a long time. They would, approve cases we thought was weaker and then RFE or even deny cases that we thought were much stronger. I'll give you an example. So for example, the RIA says you need to provide 7 years of tax returns, and which is something that most of our Chinese clients was not able to do. So, when RA first came out, it was a huge issue and there was a big debate among the lawyers about how to approach these things. And the strategy that we eventually settled on, and which has been pretty much successful in the past several years, is that if the source of funds directly relates to the past 7 years of income, then you need to provide it. And if not, then we always recommend it. But the Immigration Service has been approving cases without seeing those tax returns. However, in some recent denials that we've seen, among other reasons, one of the reasons they will list is that you didn't provide 7 years of tax returns, even though the past 7 years of income had nothing to do with their source of funds. So I think that's one area of inconsistency. Another area I would say is, I think that's pretty much that accounts for 80% probably of all the RFEs that we have received lately, which is basically dating like the old property purchase that was 10, 20 years ago, and they were not satisfied with what we provided. They always asked for bank statements for 20 years. I mean, a lot of them, they weren't even born 20 years ago, and the banking system just wouldn't support that kind of inquiry. And so far, we've been successful in defending those RFEs, but this is something that they've always asked for in some cases, but not in other cases. And this is part of, I think, the one area of inconsistency we've seen for years. Another one, I say, recently the trend is about the partial investment, because the partial investment was non-existent prior to RA, but it was always part of the law that says if you have invested or in the process of investing, you're allowed to file your EB-5 petition. And because of the larger amount and the difficulty in transferring out the money, some investors opted to do the partial investment. They invested maybe $500,000 or $400,000 first, and then they will say we're going to do that in 3 or 6 months' time. Prior to maybe October of this year, we've been doing that quite successfully with interfiling and supplying information afterwards. And even sometimes they will issue like an RFE or even a courtesy request for that kind of information. But lately we've seen that them denying RFE, or just basically saying that you haven't invested fully when you were filing, so you probably were not approvable when filed the case. So I think this is another area of inconsistency in terms of 526E petition. But like I said, I think those are the issues that we've seen many years post-RA and even pre-RA. This is something that we'll have to deal with, I guess, in the future to come. And on the non-source of funds side, I think the most concerning thing that I've seen is a treatment of the authoritarian party members, CCP members, by the consulate. As some of you know, so for many years we've been relying on case laws. They have non-meaningful involvement in the CCP. You should be okay. For many years, this hasn't really been challenged unless you're on a high-level CCP official. But the consulate, they removed the citation for the case law on the non-meaningful involvement part, which has led to massive denials on the consulate level for a lot of regular standard CCP member. And the sad thing is that because they were adjudicated overseas, there were very limited remedy, to get there's no way of appeal, and you can request for reconsideration, and they would usually just ignore. They will say no. They will have to do waiver if eligible, but not a lot of them are eligible for waivers. So it has created certainly a huge issue, and I've been advising my clients who are doing consular processing overseas, who are regular CCP members, just to wait. And there's nothing you can do unless you want to think about potential waiver down the road. Yeah, so that's pretty much what I've been seeing.